Welcome to Let's Talk Legal, where the law gets unpacked without the courtroom drama. Brought to you by NVR Attorneys, in association with Gold FM, this series tackles real legal issues, real-life situations, and the questions people usually Google at 2 a.m. Hosted by experienced attorneys who believe the law should make sense, not sound intimidating. This is legal insight, minus the jargon. Let's talk legal.
It's Let's Talk Legal time today, and we do have, of course, Dries Knoetze in studio with me. Dries, thank you so much for joining me.
Thank you, Jess. Thanks for having me.
Absolutely, and of course, this week's Let's Talk Legal is proudly made possible by Newman van Rooyen Attorneys. So today, Dries, we want to chat a little bit about, something that has to do with the Interpleader process. Now, can you tell us a little bit more about what that entails?
Thank you, Jess. Yeah, in order to explain what the Interpleader process is, I need to first explain what happens before such a process can be followed. I think the listeners will then know more or less how and what this process is. So when a judgment creditor, normally the plaintiff, obtains judgments against a debtor, the defendant, the plaintiff can issue a warrant of execution against the debtor. A warrant of execution is a court document that instructs the sheriff to approach the debtor at his residence to attach and in some instances remove movable property, such as vehicles or furniture, to sell movable property for payment of the plaintiff's claim in satisfaction of the judgment debt. So if the property which is attached or removed by the sheriff does not belong to the debtor, the defendant, then the person whose property was attached or removed can then approach the sheriff to lodge an interpleader. So in short, an interpleader is where a person, not being a judgment debtor, can make any claim to or in respect of any property attached or about to be attached in execution under the process of any court, or to the process of such property sold in execution. His claim shall be then adjudicated upon after the issue of a summons in the manner provided by the rules.
So Dries, can you also explain to us a little bit more about how that works?
Okay, so after the property has now been attached by the sheriff, any person who alleges that he is the owner or he or she is the owner of that property so attached may file with the sheriff an affidavit supported by documents to lay claim to the property. This is normally done by way of an affidavit. Normally a relative of the judgment debtor in some instances will say, but that property belongs to him or her, and then that person will also indicate on what basis does that property belong to him and why that property was in possession of the judgment debtor. So after this affidavit has been received by the sheriff will then provide a copy of that affidavit with the supporting documents to the judgment creditor, the plaintiff's attorneys, and then that will indicate that a claim has been raised and will also then request the plaintiff's attorneys for further instructions as to whether to proceed with this interpleader summons. So it will then be for the judgment creditor to either accept the claim of the person claiming the ownership of the property, or to instruct the sheriff to proceed with this interpleader and refer the matter then to the court.
Now, what happens if the claim is not accepted?
Okay, so when it's not accepted, then this claim, the sheriff will issue then a interpleader summons. Now, this interpleader summons must be served on both parties. It will be served on the claimant, the guy who says this property is mine, as well as the plaintiff's attorneys, and this will be done by the sheriff.
And what is an interpleader summons?
So interpleader summons is a summons calling both the claimant and the judgment creditor to court. It's basically the same as a warning that you should be at court, and that is then for the court to decide whether the property is legally owned by the claimant.
Now, on the cost side of things, who actually pays for this entire process?
Well, the judgment creditor is responsible for the cost of this whole process. However, if the claimant's claim to ownership of that property is dismissed, then the cost will be for the claimant's account.
Okay. And what happens if you, now as the claimant, does not attend the court proceedings?
Okay. So if the claimant then does not attend to this court date that was provided in the interpleader summons, then the claim will be dismissed, meaning that that property will then be sold on execution by the sheriff, and the funds derived from the sale will then be paid towards the judgment creditor. What is important to note that on an interpleader summons, the only matter that the court will adjudicate upon is whether or not the property so claimed is that of the claimant. Okay. The court will not be entertaining any other issues such as whether the process was followed correctly, whether the execution was followed correctly, whether the judgment that was obtained was done so correctly. The court will only focus on whether or not the guy who says he's the owner of the property is in fact the owner of the property.
Now, Dries, can you also just, explain to us, what this all also means, to the average person?
Okay, so that basically means that the only aspect that the court will consider is ownership.
Okay.
Is whether the claimant who says he's the owner of this property is in fact the owner of the property. And then the court will also consider the reasons why the debtor who the property was attached in his possession has possession of that property.
Okay. And I mean, Dries, I'm sure you have, but do you actually get these types of matters often?
Yes, we get this quite very, very frequently in our practice. Especially if you do collection matters, you get this quite frequently. But it is important to note that if your property is attached by the sheriff, you as the owner need to prove that you are the owner. And you must give a full explanation as to why this property was in the debtor's possession. It is not sufficient to just come and say to the court, well, I am the owner. Simple affidavit done by the police station normally. You will have to also inform the court and provide supporting documents such as invoices, slips where you bought this property. A prime example of this is also, it's normally when family is involved. So you are scared that your brother's stuff is being written up and now all of a sudden the property belongs to you. So it's important that not only do you convince the court that you are the owner of the property, but you must also give the court a reason why the property was with your brother. An example of this could be that you have lent it to your brother to use, but it's not just as easy to say, but well, I've lent it to him. The court will have to consider as to what the period is, why did you lend it to him. So all of that details will have to be placed before the court for the court to properly consider whether or not you are in actual fact the owner of the property.
Okay. Dries, thank you so much. And it was absolutely always a pleasure having you in studio, and we really do appreciate it. And we look forward to having you again.
Thank you, Jess. I appreciate it.
And there we have it. That was, of course, Dries Knoetze. And this Let's Talk Legal was proudly made possible by NVR Attorneys.
That's it for this episode of Let's Talk Legal. If today's topic hit close to home, don't guess, get advice. You can contact NVR Attorneys for clear, practical legal assistance, or follow the podcast for more conversations that make the law easier to live with. Because knowing where you stand is always better than finding out too late.